The big story of the day, and that is, of course, JSW Steel and the big blow that's come in from the apex court, considering the resolution of Bhushan Steel has been struck down. Abizer Diwanji, founder at NeoStrat Advisors, is with us, and he's watched a lot of this over the course of many years and decades. And I remember, right from the time the IBC law was framed, Abizer, we've been having these conversations. So what does this really mean, and where does it leave things? We all know that this use of optionally convertible debentures, this was not viewed favorably by the court. But shouldn't the company of creditors, or shouldn't the NCLT or NCLAT have struck this down at an earlier phase, at an earlier stage?
It should have, but I don't know where in the law it says that all of the funding needs to be done only by equity, first of all. I think this is the first for us. And imagine 2016 is when the law came in, and rightly so, we've been talking since. And we are now 8 years on, and we still haven't cleared everything on the interpretation side, which is shocking, if you ask me. So the new interpretation now is that you can only use equity to fund a resolution plan, which is absolutely incorrect, in my opinion. Because if you look at the IBC Act, it says that you can fund it. You can even lever the assets of the corporate debtor, as long as the equity is owned by the resolution applicant. So in this particular case, the resolution applicant did own the equity. And we are now saying that optionally convertible debentures, which in every form is debt, is not an acceptable mode of funding and should have been all equity.
Abizer, we just spoke with the partner at India Law LLP, bankruptcy IBC specialist, who've been sort of with since the IBC was introduced. Shiju, I don't know if you know him. His point was that, he made this point that, under IBC, the resolution is not like, his view was that it's not restructuring. You're not putting together an M&A transaction. It's not supposed to be. At least that's not how it was meant. So how do you view that?
It's a resolution. So IBC as a law says that we are not doing a restructuring, but we are doing a resolution. What that means is that we are not effectively restructuring the debt of the company. You have to restructure the debt of the company because that's the reason why a company is in NCLT. But what they're saying is this is not a recovery. This is a resolution. Resolution means you're keeping the enterprise stakeholders intact. What does that mean? You can reduce the debt, which most people have done, by the way. That's the reason why we have haircuts on the You can retrench people. You can reduce operational creditors. You have to correct the balance sheet of the company to be able to revive the company. That's the sole intent. Now, as part of correction of balance sheet, if we are changing the capital structure of the balance sheet, that cannot be not allowed. You cannot say that I will only equity fund it.
Okay, now...
And where is the interpretation coming from, Abizer? Because, from what our court reporter, what our colleague told us, was there were two major issues that the court had with this. One was the use of these OCDs, and the second was the delay in implementation. So if the IBC law never explicitly stated that resolution will only happen via full equity, then where has this issue arisen from?
So that's really what one needs to understand in terms of seeing the real judgment. Because as far as IBC is concerned, there really is no restriction on cap structure. In fact, it actually says that you can lever the assets of the corporate debtor. What does that mean? That means that the corporate debtor, which is the company which is in NCLT, their assets can be levered to raise money. So, by the way, if you look at what DHFL did, DHFL, the owner, Piramans, who bought the company, did take leverage on their balance sheet, which ultimately moved into the leverage of the corporate debtor's balance sheet because they merged the two companies. So effectively, what has happened? Effectively, in those resolutions also, we have gone and levered the assets of the corporate debtor. So there is precedent of leveraging the assets of the corporate debtor. What is an OCD? An OCD is a form of debt, by the way. Optionally convertible debentures, even in law, is classified as debt. It is not equity. Now, if it was permanently, it was compulsorily convertible debenture, it would have become equity. So now if debt is allowed to be levered, to be taken on the corporate debtor's assets, then I don't see on plain read where is the issue.
We'll have to look at the judgment, as you said, Abizer, and that will give us more. But now, this is as things stand. What is it? I mean, what happens from here? There are lots of banks involved, exposure. They've been paid money. So what happens operationally?
Another unprecedented thing, but I'll tell you the issues involved. One is that this company has been run by a monitoring committee and the resolution applicant, which is JSW in this case. They've been running the business. The business has turned profitable because steam turned through a cycle. Now they will say that, well, whatever the profits earned during the period is ours. Plus, there is the cost of what we put into the company. There's a cost that will be earning some kind of interest to us. Then what happens to the process now? If you put it in liquidation, just by the way, you will realize lesser value than what you realize under a resolution process. So that is going against the very tenet of IBC, which says maximization of value. Now, the other thing that the Supreme Court seems to have said is that the creditors have not exercised their commercial wisdom. While the Swiss Ribbons judgment says that the commercial wisdom of the creditors is their problem and something which the courts don't interfere on.
Right. Abizer, we have a table up on your point taken. You have a table up on which essentially highlights bank-wise recovery from the Bhushan asset. What do these banks have to do? Do they have to put this recovery amount in some separate account? I mean, how do they treat this with the judgment?
So
Indian Overseas Bank, for example, collected some 760 crores. That's the recovery. It's about 2% of the net worth.
So that will have to be put in an escrow account for now, I guess, because till the resolution, what will happen is JSW will clearly go and appeal against the judgment for sure. It will also, if at all the judgment is not appealable, then they will file for damages. And those damages will have to be met out of this. This particular consideration will have to be paid back, whatever they have actually paid. And a new process will have to be run wherein the assets will have to be liquidated because the court has requested liquidation.
Just a quick clarification, Abizer. So the IBC law is not prescriptive. You can structure the deal the way you want it, correctly? But in this case, isn't the issue that JSW Steel has not done what they had proposed to do? They proposed to fund it via equity. Instead, they have done it via equity plus OCD. Isn't that the crux of the issue in this case?
No. So they would have specified in the resolution plan that they will do a combination of OCD and equity. Now, that is what the court seems to be saying, that this is something that the COC as well as the insolvency professional should have picked up and not allowed. So ab initio, this resolution plan is not valid. And that is why they have said that, of course, the other reason being the delay. But the delay was also on a lot of other things. For example, Section 32A came about to basically give an exemption from ED acquired assets, which is basically saying that any assets which is encumbered through any other process against the promoter is released to a resolution applicant. So those kind of questions were also there. So I think that the delay has happened because of matters being sub judice and certain matters being resolved in the courts. So that is one of the reasons of the delay. The other reason of the delay, of course, is the other reason of the rejection is the capital structure, which the court seemed to have objected to, which we should look at the court judgment to figure out exactly where they opposed it. But at the end of it, what seems to be a problem is unwinding these kind of transactions after such a long time is going to be a super nightmare to do. And if it is now put into liquidation, historically liquidation has earned only a fraction of what resolution has earned. So the banks will have to provide it maybe at some stage more to what they currently are recording in their books.
What complication. Just when you think at least this one large asset was all done and dusted, simplified. By the way, I did check with our colleague Ashmit. I was very curious to know where this arose from. So the petitioner is an operational creditor, Kalyani Transco. So the operational petitioner moved this in the court. I'm assuming probably didn't get their entire dues. And then they moved the court on this.
I hope this doesn't open Pandora's box of troubles where seemingly closed transactions are now open.
Abizer, come in on this.
So one more data point on the operational creditors. Overall, the operational creditors, from what I saw of the plan, have been proportionately paid better than the financial creditors.
Oh, and then, even then they're miffed. Wonder what's going on behind the scenes here. But thank you very much. Very complex, and we'll need more of your perspective perhaps in the days and weeks ahead as well, Abizer. Thanks for taking this one. You have a good rest of your Friday. Thank you. We'll take a break on that note, come back with more market talk in just a bit.